This very famous case starts with electric blankets. In the 1950s, electric blankets were still a relatively new technology. Electric blankets with thermostats began to be used around 1936, and they started to be sold commercially just after the Second World War. In the United Kingdom, one of the more successful manufacturers of electric blankets was a company named Easy Power. The successor of that same company, now called Dreamland UK, is to this day one of the largest suppliers of electric blankets in the UK. In 1932, just 4 years before the invention of the thermostat electric blanket, the courts had invented negligence law in Donoghue and Stevenson, the snail in a bottle case. The two concepts came together in Hedley, Byrne and Heller. Easy Power had been founded by F.A. Williams, who then sold the company to a corporate group named Pina Industries. By 1958, Pina Industries itself was struggling and in fact was in liquidation. However, Easy Power, as an asset owned by Pina Industries, was doing quite well. And Easy Power wanted to build, which in this case meant advertising on the new medium of television, which incidentally also began in the UK in 1936. Electric blankets, television, negligence, what an amazing new world. Easy Power approached Hedley Byrne, who were an advertising agency. They would be able to secure broadcast slots on television and attend to actually making the advertisements, and they would also look after supporting advertising, for instance in newspapers and magazines. The initial proposal was to spend £8,000 on advertising, but in 1958 this was a fair amount of money, and Hedley Byrne was likely to be financially exposed. The reason for this is that Hedley Byrne would buy the advertising space on TV, so Hedley Byrne was liable to the TV broadcasters and newspapers regardless of whether Easy Power paid them or not. So it was crucial that they be satisfied with Easy Power's financial position. Hedley Byrne contacted its bank National Provincial, and they contacted Easy Power's bank, which was Heller and Partners, to make inquiries about Easy Power's creditworthiness. It's crucial to understand here that this information was being supplied as a mere courtesy. There was no contract for the supply of advice or information, and there was no fiduciary duty in play. It was just a gratuitous, courteous supply of information. Heller and Partners on that occasion made it clear that their advice was given without responsibility and said, "The company recently opened an account with us, believed to be respectably constituted and considered good for its normal business arrangements. The company is a subsidiary of Pina Industries Limited, which is in liquidation, but we understand that the managing director, Mr. Williams, is endeavouring to buy the shares of Easy Power from the liquidator. We believe that the company would not undertake any commitments they were unable to fill." On that basis, Hedley Byrne began to purchase advertising slots for Easy Power. Just a couple of months later, though, Easy Power wanted to really ramp up their advertising, this time to £100,000 per annum. Again, Hedley Byrne had their bank National Provincial write to Heller and Partners. The response came with a written disclaimer which said, "For your private use and without responsibility on the part of this bank or its officials." The actual content of the advice said, "Respectably constituted company, considered good for its ordinary business engagements, your figures are larger than we are accustomed to see." I've always wondered why this didn't set off alarm bells. I mean, Hedley Byrne didn't want information for their private use only. They wanted a commercial assurance. And then the bank didn't exactly say they thought Easy Power would be good for £100,000. They said Easy Power would be good for its ordinary business arrangements, but then they straight away said that these don't seem like ordinary business arrangements. Your figures are larger than we are accustomed to see. It turns out that this letter was also seriously misleading, because the only reason Easy Power was good for its ordinary business engagements was because Heller and Partners had extended a large overdraft to Easy Power. Without that large overdraft, it was a struggling company owned by an insolvent corporate group. Unfortunately for Hedley Byrne, they were reassured by the letter and started taking on advertising slots. Almost immediately, in January 1959, Easy Power went into liquidation. It was ultimately bought back by Mr. Williams, which is why it's still trading today, but the total losses of Hedley Byrne came to £15,354, 3 shillings and 6pence. They sued. There were a few immediate difficulties in the way of them suing. Hedley Byrne didn't have a contract with Heller, so it's not as though they'd paid them for advice and could argue that accuracy was an implied term of the contract. There was no equitable duty by which they could imply that Heller and Partners had a duty to put their interests first. They initially contemplated an action in fraud, but that soon fell over because the bar for proving fraud would have been very high. All they really had was an argument in negligence, and that had two key challenges. First, up to this point, the law had really not allowed negligence claims for pure economic loss. So, if negligence had simply caused a direct loss of money, that hadn't really been considered a good cause of action. Negligence was for indirect economic loss. For instance, if I negligently damage your car and you have to spend money to get it fixed. Second, liability had never really been imposed for negligent words as opposed to negligent conduct. The main reason for this was a policy-based concern that if negligent words gave rise to an action in negligence, this might open the floodgates. As Lord Morris of Borthy Jest put it, it seems to me that if A assumes a responsibility to B to tender him deliberate advice, there could be a liability if the advice is negligently given. I say could be because the ordinary courtesies and exchanges of life would become impossible if it were sought to attach legal obligation to every kindly and friendly act. In this case, though, their lordships shifted the law in two ways. First, they allowed consideration of this claim even though the only harm was pure economic loss. Lord Hodson said negligence law is not limited to a duty to be careful to avoid personal injury or injury to property, but covers a duty to avoid inflicting pecuniary loss, provided always that there is a sufficiently close relationship to give rise to a duty of care. Second, their lordships found that there could be liability for negligent words, but only in the limited circumstances where the words were spoken by a professional person who knew that others were relying on them not to be negligent. Lord Reid said, a reasonable man, knowing that he was being trusted, or that his skill and judgment were being relied on, would, I think, have three courses open to him. He could keep silent or decline to give the information or advice sought, or he could give an answer with a clear qualification that he accepted no responsibility for it, or that it was given without that reflection or inquiry which a careful answer would require. Or he could simply answer without any such qualification. If he chooses to adopt the last course, he must, I think, be held to have accepted some responsibility for his answer being given carefully, or to have accepted a relationship with the inquirer which requires him to exercise such care as the circumstances require. Lord Morris agreed, saying, if someone possessed of a special skill undertakes, quite irrespective of contract, to apply that skill for the assistance of another person who relies upon such skill, a duty of care will arise. The fact that the service is to be given by means of or by the instrumentality of words can make no difference. In this case, however, Heller and Partners escaped liability because their correspondence had clearly stated that their opinion was for private purposes and should not be relied on. So it was impossible to suggest, in Lord Morris's terms, that they had undertaken to apply their skill for the assistance of another who would rely on that skill. So they were off the hook. The responsibilities of professional people have now been modified by the various civil liability acts, but the most important effect of those acts was to establish a standard. Conduct will not be negligent if it is widely accepted by peer professional opinion, by a significant number of respected practitioners in the field as competent professional practice. The basic principle, though, that professionals, including lawyers, have a duty of care when they provide advice to others, entirely apart from their duty in contract, remains the law today, and this proposition traces its history back to Hedley, Byrne and Heller.